senators, 2 Democrats, 2 Republicans, who said they still are going to try to make it. Some have conflicts with other committees, and I want to give them the latitude and flexibility for that purpose. And one of the 4 is here now. Senator Cruz, you're recognized.
Thank you, Mr. Chairman. Judge Koh, welcome. As I look at your record is concerning from the perspective of a judge who will faithfully apply the law. As I look at your record, I see the record of someone who's been an activist her entire adult life. When you were a law student at Harvard Law School, you participated in a 25-hour sit-in in the dean's office, pressing for racial quotas in hiring at law school. At the time, you described your views of judges, where you said the problem of the American legal system was the homogeneity of the bench, and your proposed solution was, quote, minority judges still need to maintain the disguise of objectivity or else face challenges to their decisions. You went on to say, yes, that minority judge is going to identify with their own experiences, but she can't admit this. We've got to get more clever and say, look, we're just as neutral as any 60-year-old white man. What's more pragmatic, to pretend we're objective or to deconstruct objectivity itself? Now, you've tried to back away from that statement since then, but what on earth did that mean?
Let me first say I have never advocated for quotas. Quotas are unconstitutional. As I said, I do disagree with that statement completely. That was 31 years ago. Since then, I have been a federal criminal prosecutor. I have been a judge on the state court hearing 500 cases a week. I've been a federal district judge for almost 12 years, hearing 719 cases a year, and I have 3,250
So my question was, what does that
opinions.
mean? Not how many decisions have you heard as a judge? What did that mean when you said?
No, I'm just saying that there is a record to determine.
Judge, you're familiar with asking questions and answering questions. What did you mean when you said that?
It was 31 years ago. I don't recall specifically, but I'm sure I said, what I said is what I meant at the time. I think it's completely wrong. I disagree with it. That's not how I've lived my life, how I've served
So
the
I
government.
guess the challenge is what you said is that that at the time, when you were in law school, you weren't a child, you were a student at Harvard Law School. You said that judges need to maintain the disguise of objectivity and get more clever and pretend to be objective. And a difficulty for this committee is if you were following that instruction, you'd say the exact same thing right now, wouldn't you?
I am under oath, and I am telling you that I completely disagree with that statement. And you can look at the 271 trials I've had.
Then let's go to your judicial record, because as I look at your judicial record, I am concerned as well. Recently, you determined that a state regulation that banned Bible study, that banned collective prayer, that banned worship in an individual's home, while at the same time allowing activities like in-home commercial filming, was neutral and generally applicable. According to you, according to the decision, apparently people who attend Bible study are a greater threat under COVID than movie stars when it comes to health and responsibility. Now, that decision, of course, went up to the U.S. Supreme Court in 6-3. The Supreme Court said, no, you're wrong. What did you get wrong?
The Supreme Court in Tandon has held that when you're looking at comparable activity, you look at the government interest that's asserted and not the reasons why people are gathering. That clarification has been very important. That is what I will fully, faithfully, and fairly apply going forward. They also
Why
said
did you
can't
think
assume.
that movie stars somehow are held to a different standard than people coming to a Bible study?
I was following the Ninth Circuit precedent. They looked at all the restrictions on the movie industry and said that the risk transmission risk was lower because of all the restrictions. They had mandatory multiple testings per week, and they had a lot of restrictions that said that they had scientific evidence that the risk was lower.
Your opinion applied rational scrutiny to this restriction on religious freedom. The Supreme Court reversed that and applied strict scrutiny. There's a world of difference between rational basis and strict scrutiny. Again, why did you get it so wrong? And how can the American people have comfort that if you're a Court of Appeals judge, you will faithfully protect their rights to religious liberty?
I applied strict scrutiny as well, and I was following Ninth Circuit precedent at the time, which said you look at the risks of transmission and you go through 7 factors to consider it. And at the time, the Sixth Circuit decision, which was not enjoined by the Supreme Court, said if you have a neutral, generally applicable rule that applies to both religious schools and public schools and other private schools, that survives strict scrutiny. And so the precedent that existed at the time is what I followed in issuing my decision.
Could you answer my second question?
I fully understand that Tandon is the law of the land. That is absolutely what I will follow, that you cannot assume the worst when people go to worship and assume the best when they go to work, and that you have to look at the government interest at stake, and that all of the rulings and holdings in Tandon, that's the law of the land. That's what I will apply going forward in any case that raises these issues.
Thank you, Senator Cruz, Senator Ossoff, Senator Blackburn, and Senator Padilla.
I was going to say Captain Kirk, but
John Luke Picard, the haircut, the John
Senator
Luke Picard.
Booker, I have an affinity for Star Trek as well. Maybe we should start a Star Trek caucus.
I agree.
Judge Coe, thank you for being here. Congratulations on your nomination, and congratulations to your family. I know they're probably all proud. I just want to go back briefly. I'm not going to read the statement that Senator Kennedy read. When I asked you about this in 2016, you said you completely disagree with that. I think one of the reasons why we go back 31 years and longer is the standard keeps moving here. We've gone back to high school yearbooks for what some teenager said or wrote in their yearbook as a basis for judging someone's qualifications as judge. I tend to disagree with it, but I do want to ask you a question that really an abstract. Because when you read the statement, it does say that you need to disguise it. So when you answered me back in 2016 that you completely disagreed, can I be absolutely certain that you're still not disguising that bias? And maybe one way that you could put me at ease is maybe describe some case in abstract. I know you probably won't want to get into details where you may have had a certain sympathy, but you had to make a decision in the other direction. Have you ever had an experience like that as a judge?
When I preside over any case, my personal feelings are irrelevant. That's not my job. And I appreciate that you're taking your advice and consent role very seriously. And I understand that statement is disturbing. It's disturbing to me.
I think
so I think it's completely a fair question, but I completely disagree with it. And I think if you look at 3,250 written opinions and the thousands of issued rulings I made on the state court, having 500 cases a week, you can see that I have been fair and impartial. My judicial oath is so important to me, and I completely do my level best to be fair and impartial in every case and to try to get it right by limiting my decisions to the facts before me, limiting my rulings to the issues before me, and following precedent. Now, as I've said, I may not get it right all the time, but that's what I'm trying.
I want to get back to, I'm the ranking member, previously the chair of the Intellectual Property Subcommittee, so I do have to get back to Qualcomm. And as Senator Cotton said, it was characterized as a trailblazing application of antitrust laws and an improper excursion beyond the outer limits of the Sherman Act. So I think you said that you wrote a more than 200-page opinion Was
I
that
did 233 pages of factual findings and
that it was
credibility findings.
largely, or that it was at least substantially influenced by the prior Motorola case? So
That's correct.
and that was Ninth Circuit precedent. So do you, looking back at their assessment of what is now a vacated opinion, do you agree with the Ninth Circuit's interpretation in the context of the Motorola case and in the context of your finding?
The Ninth Circuit decision is the controlling law, and that is what I'm going to apply.
But I mean, it's more a matter of, and I'm not an attorney, so I don't
Yes.
know if I get you into a position where you can't answer the question based on other cases that may come before the court. But I'm looking more at more of a, I didn't think about it that way when I was writing my opinion, because they looked at the same thing. They looked at binding precedent, and then they looked at your ruling. And so I'm just trying to get a sense, did you learn from that and say, if I'd really viewed it from that perspective, I would have ruled differently?
For me, antitrust is a really complex area of the law, and I certainly can see that there are different viewpoints. The Ninth Circuit did not address this standard-setting body FRAND obligation directly. They just said the remedy should be in contract, or it should be in patent, and shouldn't be an antitrust law. Yeah. So they didn't actually address Microsoft v. Motorola head on.
Về thôn em duyên dáng bên ven sông con thuyền xuôi mãi, nhịp cầu băng qua men lối đi quanh con ngõ hoa nối dài. Nhà em cuối xóm ghép đôi mái tranh nâu trắng cài trước sau, có tầm mến thương dâu, có trầu vấn vương cao và đào tơ thơm ngát ngát hương trinh ban đầu. Đường về thôn anh con sáo ru êm trên đồng xanh lúa, nhịp cầu băng qua đưa lối dân rêu xưa thăm hoa bốn mùa. Nhà anh mãi lá tháng năm vẫn chưa nghe duyên tròn ước mơ, có dàn mướp xanh lơ, có hồ cá nên thơ, mà lòng quê vẫn hát bao câu mong chờ. Hội mùa lên tiếng ca góp tay ta cần lao, ôi hai thôn giao đầu nhịp cầu che bước chung êm vui dương bao. Tình ta lên men rồi còn chỉ ngăn cách lòng, mà chưa trao giấc mơ xuân cùng nhau. Chảy dâng lên trăng màu, bà con đang mong cầu rằng đôi ta sớm nên duyên ban đầu. Đường về hai thôn mai mốt đôi uyên ương qua cầu soi bóng, nhủ thầm sông ơi gương nước chưa phôi phai ta còn vui hoài. Trời quê bát ngát sẽ trông thấy tương lai qua tình lứa đôi, lúa đồng mãi xanh tươi mướp cà thắm nơi nơi, và vành môi trai gái hát câu ca yêu đời. chưa trao giấc mơ xuân cùng nhau. Chảy dâng lên trăng màu, bà con đang mong cầu rằng đôi ta sớm nên duyên ban đầu. Đường về hai thôn mai mốt đôi uyên ương qua cầu soi bóng. Nhủ thầm sông ơi gương nước chưa phôi phai, ta còn vui hoài. Trời quê bát ngát sẽ trông thấy tương lai qua tình lứa đôi. Lúa đồng mãi xanh tươi, mướp cà thắm nơi nơi và vành môi trai gái